And what we're going to talk about through this is just a practical refresh on screening, scoping, and the EIA report kind of submission to consent and what you guys are doing in relation to that. So in relation to these, certainly the first two for screening and scoping, what I'm going to talk about is just some good practice or refresh your good practice understanding of screening opinions and scoping opinions, and go through two resources, the diagrams that are available on the National Planning Hub's EIA pages. There isn't such a diagram for the examination of EIA report to determination of application, so there's just a few kind of refresher slides for those. The web link there for the screening opinions subpage, these obviously will be in the recording. And now to just dive in to our practical overview diagram for Schedule 2 screening. So you'll recall there are these developments termed Schedule 2 developments, and these are projects that may or may not require an EIA. And effectively, we've got two tasks. First task as a planning officer is to check whether a screening opinion is actually going to be required. And that is all about kind of understanding, is this a Schedule 2 development, or is it not a Schedule 2 development? If we determine it is a Schedule 2 development, it needs a screening decision before it can be consented. If we decide it isn't, it can progress as an ordinary application. And then if we decide it is required, then we go on to task 2, which is to confirm whether the proposal actually needs an EIA or not. And that is the screening opinion process of actually issuing the screening opinion and making that opinion. So this is the first diagram, and those links link through to the next two pages. The first part of the diagram that is available on the MPH webpage. So that first task, what are we doing? Well, we are confirming whether something is a Schedule 2 development or not. So what, as a planning officer, we need to do is look, is the proposed development of a type that's listed in the first column of Schedule 2 of the EIA regulations? And if our answer is yes, then what we've got to consider is either one or two of the things that are going to appear shortly on the screen are applicable. So if it's listed in the first column and it is either in a sensitive area, any part of that proposal goes within a sensitive area, or a sensitive area is within that proposal. What I mean by that is, a scheduled monument might be quite small and the proposed development area may be entirely around the scheduled monument. So if it's in that first column and it's in a sensitive area, it's Schedule 2 development, we need to screen it. If it's not in a sensitive area, then we need to look across to the corresponding second column in relation to our development type and look at the thresholds and criteria that are set there. So some of these are, so for an urban development project, 0.5 hectares, a kind of spatial area is defined. If our development is 0.5 hectares or above that, then it is going to be a Schedule 2 development. If it's 0.4 hectares, then it is not. So there are various bits of advice that sit alongside this diagram to give you advice in terms of what the type of categories are, what those sensitivities are, and and the fact that each of the different development types listed in Schedule 2 column 1 have their own specific thresholds and criteria. So it isn't that they're all standard. Most of them are kind of land take or area based, but they all differ, and some of them in terms of the units and that type of thing differ as well. So if we're saying yes, it's covered in this first column and it's in a sensitive area or it's above the thresholds, we're going to need to move on to task 2 for the screening opinion. If we identify that it doesn't match the types listed in column 1, or it either it is both not in a sensitive area and it's below those thresholds, then it's not going to need to be screened to determine whether an EIA is required. So where we need to go on and produce a screening opinion, then the planning officer's activities are kind of threefold. One of them is judgment in itself. And what we're looking for there is, do we consider that the proposed development is likely to have significant effects on the environment? And if our answer is yes, even one significant environmental effect, then we should be triggering an EIA. It becomes EIA development. If our answer is no, then EIA is not required. So the first thing is understanding the information there and making a judgment. The next component is writing that judgment, that thought process, the relevant evidence for that into your actual screening opinion. So documenting your judgment, making a written statement and justifying how you've drawn your conclusions, drawing across the evidence that you've looked at, and there's a requirement that you link that into consideration of the criteria set out in Schedule 3. And then the third task in making a screening opinion is communication of that opinion. So it needs to be sent out to the developer, but also made available to the public on a website, and therefore becomes part of the public record. And again, there are on the diagram, there's various advice and guidance to help you understanding that. So that's our quick whistle-stop tour of screening and the diagram to help with that. On the Scoping Hub, or the Scoping page of the National Planning Hub, we have another diagram in relation to making a scoping opinion. And again, it's just trying to set out what are the key practical steps, reminders, advice for those. So the first step is that the developer actually makes a request for a scoping opinion. That's a voluntary activity, but if they do choose to do that, it's going to trigger some formal activity by yourselves. So you get a developer's request for a scoping opinion. What should I include in my EIA report? Then there's a requirement for you guys to undertake consultation with the consultation bodies and others. We'll go on to those on the next pages. The third step, once you've initiated that consultation, is you actually review the request yourself. It is the planning authority's scoping opinion, so you need to develop that opinion, and you may get some consultation responses, you may not get consultation responses from those statutory bodies. And then finally, again, as with the screening opinion that we've just discussed, there's the requirement to communicate that. So request and what's made in that request, trigger consultation to certain parties, making your own opinion, but drawing on the evidence that you have available and then communicating it. And the subpages that support that core flow diagram have kind of advice for you in terms of the scoping request. What do the regulations say need to be in there? The fact that you as a planning officer should be checking to make sure that it's got sufficient information to enable you to make your scoping opinion. If you think it hasn't got sufficient information, then you need to get back to the developer in 21 days. But obviously be aware that actually what the regulations cover in relation to a scoping request are quite broad and quite loose. And then the next step, consultation, advice on that process. Who are the statutory consultees is set out there. Who are these other parties that you might need to consult while relevant? So it isn't just all of your standard planning consultees that you would go to for any planning application. These are the ones that are set out in the EIA regulations. So I saw some reference the other day in relation to a Scottish Planning Authority's screening opinion saying, scoping opinion, apologies, saying the MOD hadn't come back as part of our consultation, and therefore we weren't sure whether we should issue our scoping opinion or not. Well, the MOD isn't actually kind of formally required to be part of that through the EIA regulations. So if you want to include them, it's entirely up to you, but you shouldn't necessarily be holding back if they haven't responded. And in fact, it is your scoping opinion. So even if none of the statutory consultees have responded, you should, as a planning authority, be able to bring some views and some judgment forward. That's the advice that step 3 sets out in terms of forming the scoping opinion. In every case, you should be focusing on forming your own opinion. What are your perspectives as a planning authority, as a planning officer, in relation to the information in front of you? And in doing that process, you are expected to take into account what's been provided by the developer in terms of where it is, its location, its likely environmental consequences. And of course, if you do receive response from those you consulted in step 2, then fantastic, you can use that information and should be using that information. And of course, be aware it's the planning authority's viewpoint, but as a wider council, you will have other staff. So there are those internal consultees, if you still have them in terms of ecology, heritage specialists, etc., that you may well be able to have some conversations with. And there's further advice, obviously, on the scoping webpage and in the circular and pan for that. And then finally, a box providing some advice in terms of communication of the opinion, the fact that it should be produced within 35 days. If you want to go beyond that, then you need to have a written agreement with the developer, and then also highlighting the fact that there is the opportunity for the developer to get a scoping direction from the Scottish ministers if they don't receive your opinion within the 35 days or longer period as it's been agreed. But obviously still very useful them to get actually your opinion, because you guys are going to be the consenting authority in relation to that. So do need to move on, but that diagram is available on the Planning Hub web pages. So do please take a look at it, download it, use it as kind of advice alongside rewatching the recordings of those webinars. So we're now just going to move on to quickly refresh ourselves on the actual process of from the submission of the EIA report, your examination of the environmental information, etc. So just a kind of quick reminder and highlight. We are prohibited from granting consent for an EIA development unless we have delivered the environmental impact assessment, unless that has been carried out. And there's a definition in the regulations under Regulation 4.1 as to what that core of that EIA process is defined as. So the preparation of the EIA report by developer is the first step in that definition. So all of what we've just talked about in terms of screening and scoping kind of sits within, leading to that preparation of that that first bullet there. And then the rest of the activities really sit with you, the carrying out of the consultation, publication and notification, the examination by yourselves of the information presented in the EIA report and other environmental information. We'll talk about what that means on the next slide. Having done that examination, coming to your own conclusion, the planning authority's reasoned conclusions on the significant effects of the development on the environment, and making sure that those reasoned conclusions are integrated into the actual decision process and then ultimately available in the decision notice that comes out afterwards. So in terms of what are we examining, it's environmental information. Environmental information is defined within Regulation 2, so not necessarily where it's talking about the fact that you need to do the examination in the regs. It's defined earlier in the document. It's the EIA report that the developer submits. It's any additional information that has been submitted by the developer in respect of the development. It's any representations that are made by any consultation body or other public body that has been consulted, and it's any representations made by any other person about the environmental effects in relation to the development. So the consultation response doesn't have to necessarily be about the EIA reports. It can be a response in relation to the application, planning application itself, and reference the environment. You need to be taking all of that evidence into account when you're doing your examination. So looking at the EIA report is obviously very important, but make sure you're also looking at the representations and looking across those, bringing your own opinion as to what your conclusions are on significant effect. So the examination itself, it's more than just what we had before the 2017 regulations, where we were giving consideration to the documents that were submitted. So it's somewhat of a thorough and detailed analysis across the environmental evidence that is coming in for the proposed development. But think about what EIA is really after and what is critical for your decision process. So you're there to make reasoned conclusions on significant effect. So you want to be focusing on where are there indications that there may be significant effect. Maybe those significant effects have been mitigated or not. And if they have been mitigated, then it might be a case that you need to put some conditions in to ensure that those measures are delivered post-consent in the construction or operation, or to monitor the delivery of those to make sure that they're working. And then just finally, in terms of the type of thinking we might be thinking about as planning officers through the examination of information, environmental information, need to make sure we understand the development, very important. Obviously, what Neil was saying, what is the project? And looking through the EIA reports, non-technical summary, very, very useful to get an oversight of where the significant effects might be. Seeking to prioritize within the topic chapters, where are significant adverse effects? Where are the differences between what the EIA report is saying and what's coming in representation, and understanding those, possibly using a bit of a storyboard or something to understand where those sit. That's going to help you focus on those key issues, significant findings, what are the proposed mitigations, and then work back into the wider evidence that's been provided to make sure your judgments are satisfied as to the conclusions you're drawing. And of course, if necessary, there is the opportunity to request supplementary information, but we're really meant to be doing that linking to help us make our reasoned conclusions on significance, so he isn't there to simply dot I's and cross T's.